Hey, Patty.
Hey, hi, how are you?
Hi, good to see you.
You?
Have you been? I've seen you on Zoom.
I'm actually extremely busy. I
You
have
always are.
publications lined up.
That's wonderful.
You know, that with deadlines that are, in some cases, long past.
Yeah.
And then I just got, actually involved in some litigation, so just got hit with having to file, I mean, not personally,
Right.
not being sued,
Right.
don't get me wrong, out in Utah. So,
In relation to cultural property issues?
yeah, something called the Antiquities Act
Uh-huh.
of 1906, and it's monument declaration. This is first by Obama, and then Trump, and then
Right.
Biden. You're saying it as if you know what I'm
A
talking
little
about.
bit.
Oh, okay. So I work with 3 archaeological organizations trying to get intervener status.
Oh, wonderful.
And get all documentation. Yes, that's okay.
If we do need to run you a handheld, I'm just going to do that for you. Okay, so if I run up with a handheld mic, it just means that the stream is
Come on, you're welcome. Keep control of it. Absolutely.
So are you in federal district court out there?
Yeah.
Okay.
This is the first problem. We have lawyers representing us who are in Denver. And they told us like 2 weeks ago that they don't have any lawyers in Utah. So we had to find a good lawyer, you know, who
You can file things for it. Yeah.
Utah.
Right.
And actually I went out for about a week at the end of October I went to one of the monuments to check it out and get an idea of what was going on. And I was considering
Is it a
becoming
Native
cleric,
American
so-
site? Or?
It's, yeah, mostly
Yeah.
Native American.
It's fascinating
Different
stuff.
time periods. Oh, and the trip was fantastic. Seeing it all. Great. So,
Well, I've got a couple of Seventh Circuit cases. I've got an oral argument in a couple of weeks, actually.
what kind of issues?
Well, one of them is just a plaintiff side personal injury appeal. Uh,
I went out and I used your conflicts book and love it.
Oh, wonderful.
So I just wanted to say hello.
We got like 1 or 2 more minutes,
Yeah,
if that's
sure.
okay with you. And then at the end, do you want me to help facilitate question? I will give people a mic just because we're on live stream, so they need a mic to be able to.
However you'd like to do it.
Okay.
Yeah, I mean, I can just do it.
Okay. You can facilitate, and then I will be the mic runner for people.
Thank you so
Does that sound
much.
good?
And then do I just start?
Yeah. So, well,
Perfect.
I'm going to introduce you,
Okay.
actually, and then you can
Okay.
go for it.
Keep it nice and short, though. No need for an elaborate intro.
No, I highlighted like 2 things.
Perfect. Perfect.
I figure people are going to want to know that you worked with Ruth Bader Ginsburg, so I'll say that.
Okay.
That
Fair
they
enough.
will find that interesting.
Sure. So how long have you been here?
Good evening, everyone. We're going to go ahead and get started. Thank you so much for joining us this evening here in person and those who are joining us via live stream as well. We welcome you to Sukkot Shalom and to our guest scholar lecture of fall 2022. This has been a long-standing program that we've had for many years. And I want to first give a thank you to Judy Buckman for helping to arrange the guest scholar, as well as our Director of Education, Missy Bell, and our partners at First Congregational Church, the Reverend Lark Hapke. We welcome you, and thank you for being here, and thank you for your partnership. Tonight, our guest scholar is Professor David Franklin, who teaches constitutional law, administrative law, and First Amendment and conflict of law at DePaul University. He graduated from Yale University and got his JD from the University of Chicago. He also worked as a law clerk for Justice Ruth Bader Ginsburg of the United States Supreme Court. David will speak to us this evening on the Constitution and religion under today's Supreme Court. And I'll turn it over to you, David. Thank you.
Thank you so much, Rabbi Daniels, and thanks to Judy Buckman for helping to organize tonight, and to all of you for coming out on a rather chilly November Sunday evening to hear about the relationship between religion and government in the United States. So I want to tell you a story about that relationship. More specifically, I want to talk about what the Constitution has to say about the relationship between religion and government. And even more specifically, what the Supreme Court has to say about what the Constitution has to say about the relationship between religion and government. So on your screen there is a sentence from the First Amendment. It's the very first sentence in the Bill of Rights. So you can imagine the framers of our Constitution thought that this was pretty important. And what you have here are the so-called religion clauses. Clauses, plural, because there are two of them. An establishment clause and a free exercise clause. And so we're going to be talking a lot about these two clauses and how they've been interpreted. But broadly speaking, what these clauses do is they place some limitations, right, on what the government is permitted to do. That's the way constitutional rights work generally in our system of judicial review. And so the Establishment Clause and the Free Exercise Clause in some ways go hand in hand, which is to say that both of them are aimed at ensuring a space for freedom of conscience in our society and in our polity, right? But there also may be some ways that we'll talk about tonight that the two clauses might pull in opposite directions from one another or be in some tension with one another, and we'll explore that together as well. So let's start with the Establishment Clause. That's this part. Congress shall make no law respecting an establishment of religion. Okay, so what does that mean? No law respecting an establishment of religion. Well, over the years, lawyers and commentators and judges and justices of the Supreme Court have answered that question in different ways. Let me show you the sort of first answer, the oldest answer that the Supreme Court has given to this question of what the Establishment Clause means. Now, I'm going to show you a rather lengthy quote here from a case from 1947 called Everson. This was the very first case in which the U.S. Supreme Court interpreted the Establishment Clause. Right away, that's interesting because the Establishment Clause had existed for 150 plus years, at the time of the Everson case, but the Supreme Court had not gotten around to interpreting it yet. The main reason for that is because it took until the 1940s for the Supreme Court to decide that the Establishment Clause applies to the actions of state and local governments. Okay, if you go back and you look at the text of the Establishment Clause, you'll see it says, Congress, right? Congress shall make no law respecting an establishment of religion. Well, Congress obviously is our federal legislature. But then over the course of the 20th century, the first half of the 20th century, the Supreme Court gradually decided that a whole bunch of rights that are enumerated in the Bill of Rights, like this one, apply not just against the federal government, Congress, but also against state and local governments. That was a lengthy process of what's called incorporation of the Bill of Rights against the states. And so it wasn't until 1947 that the court decided that the Establishment Clause applies. So it applies to Illinois, to the government of Wilmette, et cetera, in addition to the federal government. So the man you see there is Justice Hugo Black of the Supreme Court. In my book, probably the most interesting Supreme Court justice of the 20th century. He's got a lot of competition in that regard, but I'm prepared to defend that statement another time. But Hugo Black wrote in his opinion, I won't read all of it, but he says, the Establishment Clause means at least this: neither a state nor the federal government can set up a church. Okay, that's sort of table stakes, right? That's common ground. Everyone understands that the framers, right, didn't want governments to establish religions. In fact, in most of the states at the time of the founding, there were established religions, whether Anglican in, say, Virginia or Congregationalist in New England. And so one of the ideas of the Establishment Clause is we don't want to have an official church, thank you very much, right? So that's the basic meaning of the Establishment Clause. But Hugo Black goes on. He says, neither government, state or federal, can pass laws which aid one religion, aid all religions, or prefer one religion over another. No tax in any amount, large or small, can be levied to support any religious activities or institutions. And then he concludes in the words of Jefferson, the clause against establishment of religion by law was intended to erect a wall of separation between church and state. So that metaphor of the wall of separation should be familiar to all of us. I think it's probably the most familiar metaphor in religion clause jurisprudence, if not all of constitutional law. So that's where the court started, okay, 75 years ago in the Everson case. But that's not necessarily where the story ends by any means, because over the years, we've seen on the Supreme Court a number of competing visions of the Establishment Clause. So we've just talked about strict separationism, right? This high wall of separation between church and state. But many justices have been attracted to a less robust, less aggressive understanding of the Establishment Clause. What would that mean? Well, one possibility is the idea that the Establishment Clause simply requires the government to be neutral, okay, as to matters of religion. So you can see how that's a less aggressive understanding than what Hugo Black gave us in the Everson case. But I think it's motivated by the justices' understanding that full separation between religion and government is not possible, or at least not in our society, right? In fact, in the Everson case itself, I didn't tell you anything about the actual case, but the Supreme Court actually upheld a program that provided government funds to reimburse school children and their families for transportation expenses to and from schools, including religious schools. Now, if Justice Black had been serious that no government aid can flow to religious institutions of any kind, he would have been compelled to strike down that program. But he didn't. And he didn't in part because the program was neutral, right? It made its funds available to all families, right? There are competing visions of neutrality. We could talk about an obligation on the part of the government to be neutral among religions. We could call this non-preferentialism if we wanted to be fancy and multisyllabic. Or we could talk about a broader sense of neutrality, which requires neutrality not just among religions, but also between religion and non-religion, if you will, a kind of strict neutrality approach. Okay, so that's another vision of the Establishment Clause. Here's another one. Non-coercion. The idea here is much more modest, right? It's not that the government has to be neutral about religion. Rather, the government simply has to make sure that it doesn't compel anyone to worship or to support religion, right? So that's an even less aggressive vision. And we can talk about different understandings of what coercion means, and we will a little later on tonight. There's one more vision of the Establishment Clause I'll just mention very quickly that's associated with Justice Clarence Thomas, and that's the idea that the Establishment Clause actually was never meant to be incorporated against state or local governments at all. So if Justice Thomas had his way, the Establishment Clause would not apply to the state of Illinois or the town of Wilmette. Thus far, Justice Thomas only has one buyer on the court for this. That's Justice Gorsuch. There are only 2 votes for this disincorporation vision, but I thought I'd mention it so you're aware of it. Okay, so we start with strict separation in the Everson case, right? Where do we go from there? Well, by the early 1970s, the Supreme Court had developed a test for determining whether laws were constitutional under the Establishment Clause. Okay, the test comes from a case called Lemon versus Kurtzman. And so here it is. Here's the Lemon test. The court in the Lemon case, 1971, said that for a statute to be constitutional under the Establishment Clause, it had to meet 3 tests. First, the law has to have a secular purpose. Second, the law has to have an effect that neither advances nor inhibits religion. So there's your neutrality idea, right? And third, the law can't foster what the court called an excessive entanglement between government and religion. Okay, so that's the Lemon test. And by this point, the court had decided, for example, in the early 1960s, that school prayer, if it was part of the official school day, right, led by a teacher, for example, was unconstitutional, even if students had the opportunity to opt out. And what the court had said in those early 1960s school prayer cases was the government can't be in the business of sponsoring a prayer and telling students they can opt out, go out into the hallway, or even show up to school a little bit later than their classmates. That doesn't cure the problem. That actually makes the problem worse, the court said, because it forces those dissident students to mark themselves as outsiders, and we don't want that either, okay? And so the Lemon test sort of embodies some of the lessons of the school prayer cases. So as soon as the Lemon test came down in the early 1970s, it was unpopular, especially with conservatives and conservative justices. And the conservatives began to criticize the Lemon test almost from the very beginning. One of the key critics of the Lemon test was Justice Antonin Scalia. Let me show you something that Justice Scalia said about the Lemon test after he got onto the Supreme Court. And since Halloween was fairly recent, I'm just warning you, this is a little bit spooky, okay? So Justice Scalia wrote, like some ghoul in a late-night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed and buried, Lemon stalks our Establishment Clause jurisprudence once again. So basically, Scalia says this Lemon test which was the result, by the way, of an 8-1 majority written by conservative Supreme Court Chief Justice Warren Burger, was some sort of undead zombie that we should all be afraid of and that we keep trying to kill and it never quite dies. So I want to just give you a flavor for the court's treatment of the Establishment Clause by talking about a couple of cases. One from 30 years ago, and one from just this past spring. Okay, so let's start 30 years ago. A case called Lee versus Weissman from 1992. Here's what happened in this case. There was a middle school graduation in a public high school, or public middle school, rather, in Providence, Rhode Island. And the school district invited a rabbi to come and give an invocation and a benediction, sort of to congratulate the middle school students on this milestone. Okay, and the invocation that he gave, I don't remember it word for word, but it's very kind of vanilla. It sort of partakes of American patriotism and civic religion. You know, it says things like, God of the free, hope of the brave, we thank you for this country where we all have equal rights and a chance to thrive. You know, this kind of thing. Very ecumenical. I'm not even sure if ecumenical is the right word for it. But notwithstanding those features of the invocation, one of the students, Deborah Weissman, aided by her parents, decided to sue. Her view was that the school district, the school, public school, right, a state actor, shouldn't be in the business of bringing religion into this space. Case makes it all the way to the Supreme Court. And the Supreme Court agrees with Deborah Weissman. In an opinion by Justice Anthony Kennedy, the court strikes down this program under which members of the local clergy, one year it might be a rabbi, the next year a minister, a priest, an imam, were invited into the public school setting to give these invocations. And Justice Kennedy's opinion was based on this idea of non-coercion that I mentioned earlier. And what he says is very interesting. He says, it's true that the Providence School District isn't strictly requiring these middle school students to do anything. No one's being required to worship or even say amen or stand up. But on the other hand, he says, it's their middle school graduation, right? You can't not go, right? And once you're there, there's peer pressure to sit and be respectful and sort of allow this thing to happen around you. And that, he says, is included in the kinds of coercion that the Constitution prohibits. And so Kennedy writes, the government may no more use social pressure to enforce orthodoxy than it may use more direct means like the criminal laws or the tax laws. Okay, so that's Lee versus Weissman, 1992. Now, fast forward 30 years to this past spring, and the case of Kennedy versus Bremerton School District. Some of you may be aware of this from the newspapers, right? This was the case about a high school football coach in the state of Washington who began to go out to the 50-yard line after games and very publicly pray. And once he started to do this, his team, his players started to join him. Sometimes players from the other team would join in as well. And eventually, somebody, the sort of Deborah Weissman of our time, decided to sue about this and say, look, it's just like Lee versus Weissman, right? The public school should not be in the business of effectively sponsoring, right, a moment of prayer, okay? And ultimately, the school district for which this coach worked suspended him, and he was not rehired for the next season. Now, unlike Lee versus Weissman, where the dissenting student was the one who brought the lawsuit, in this case, it was the coach. The coach then sued the school district, saying, by suspending me, you're violating my rights of free speech and free exercise, which is the clause we're going to talk about in just a minute. One of the things about this case that's so striking is the way in which the Supreme Court cherry picks or even distorts the facts of the case. So when you read the opinion by Justice Neil Gorsuch agreeing that this coach's rights were violated, what you find is the court saying, this was just a private moment. It was a silent prayer. Students felt no compulsion to join in. It was during a time right after the game where everyone was free to do whatever they wanted, check their phone, go and talk to their friend, hang out in the parking lot or whatever. It was basically a private moment of individual speech by the coach. That's not what the trial court actually found in the case, so the Supreme Court was playing a little bit fast and loose with the facts. But what the school district had said, right, in this case was, we asked the coach to stop doing these prayers. He refused. And so we had to suspend him because we, the school district, did not want to be in violation of the Establishment Clause, right, under Lee versus Weissman, okay? But the Supreme Court rejected that. It said, that's not the way this went down. The suspension of the coach was not necessary in order to avoid an Establishment Clause violation. And Justice Gorsuch says, the different parts of the First Amendment, establishment, free exercise, they're all in harmony with one another. There's no tension there, pulling on the same rope, as it were. Now, the other thing I'll mention about the Bremerton case is that the Supreme Court, with, of course, now its 6-3 conservative supermajority, finally managed to do what they've been wanting to do for 50 years, which was to overrule the Lemon test. And here's what the court said, quote, the shortcomings associated with this ambitious, abstract, and ahistorical approach to the Establishment Clause became so apparent that this court long ago abandoned Lemon. That's remarkable. So, in fact, the court technically doesn't overrule Lemon versus Kurtzman. Instead, it sort of observes somehow that Lemon has actually already been, quote unquote, abandoned, okay? The very strange thing, this is how judicial precedents go, not with a bang, but with a whimper, right? Like, well, we're not going to overrule it today. We're just going to recognize that it's already dead. So I guess the zombie had enough stakes driven through its heart that it finally died, right? The court does not, however, overrule Lee versus Weissman. It sort of says, well, that was different because middle school students are subject to more peer pressure or something. It's not a very convincing attempt to distinguish the Lee case. And you can tell that Justice Gorsuch and his colleagues wouldn't have signed on to Lee if they had been on the court back when that decision was rendered. So Justice Kennedy's decision in Lee is sort of distinguished and set aside, in a way, by Justice Kennedy's former law clerk, Neil Gorsuch, in an opinion involving a coach named Kennedy. Okay, let's talk about the free exercise clause. So that's this part of the First Amendment. Congress shall make no law, and by extension, of course, that means states and local governments shall make no law, prohibiting the free exercise of religion. As I said earlier, we can certainly see ways in which the Establishment Clause and the Free Exercise Clause go hand in hand to create that space for freedom of conscience. But I also said earlier that there's possibilities of tension between these two clauses. So let me say a little bit more about that. What do I mean by tension between the two religion clauses? Well, this issue of possible tension arises in a case like the Coach Kennedy case that we just talked about, right? Where a school district said, we have to suspend this coach because we don't want to be in violation of the Establishment Clause. And ultimately the court says, no, you're actually in violation of the free exercise clause, right? Here's another way in which the two clauses can come into some tension with one another. And it has to do with the idea of government accommodating private religious choices. So we can imagine there are all sorts of ways, right, that people might want to act in order to conduct their lives in a way that's consistent with their religious values and beliefs, right? That could come into conflict with various laws. And what happens at that moment, right? Well, one possibility is that the government can say, yes, we have a law on the books, but we understand that you're a sincere religious practitioner, and so we're going to accommodate your religious beliefs and values, right? How does the Constitution handle those moments? Well, one possibility is that accommodations of religion are prohibited by the Establishment Clause. I'll give you an example. In upstate New York, there is a town called Kiryas Yoel that is almost entirely populated by the Satmar Hasidim, who are Orthodox Jews whose roots are in Hungary. And the Satmar Hasidim realized that, so most of their kids go to yeshiva, to private Jewish schools, but some of their kids need special help, special education. Their own schools were not capable of delivering that. And so what they did is they went to Albany, they went to the legislature in New York, and they said, can you create a special school district just for us? So 100% of the students in this school district were going to be from this particular Orthodox sect, okay? This was challenged as a violation of the Establishment Clause, and the Supreme Court agreed it was unconstitutional for New York to effectively gerrymander a special district for one religious sect. So in that admittedly unusual context, the court is effectively saying, right, that this accommodation of religion is in fact prohibited by the Establishment Clause. Okay, and I could give you other examples having to do, for example, with a government-sponsored nativity scene, you know, out in front of City Hall, okay, if it's just got Jesus and Joseph and Mary and three wise men and nothing else, okay, that's probably unconstitutional under the Establishment Clause, at least under prevailing doctrine from the 1980s and 90s. Okay, so that's one possibility. On the other end of the scale, though, it's possible that accommodations of religion are not just not prohibited by the Establishment Clause, but might even be required by the Free Exercise Clause. And we'll talk about some examples of that in just a few minutes. Now that's tension, right, between two constitutional clauses. If one part of the First Amendment, right, arguably prohibits something, and the very next clause arguably requires that very same thing, right, then we've got some work to do to figure out the relationship between these two clauses, okay? Now, I've left some room in the middle because it's certainly possible that in between what is prohibited by the Establishment Clause and what is required by the Free Exercise Clause is a kind of zone of legislative discretion, okay, where government accommodations of religion are neither prohibited nor required, but just sort of up to the government. And I'll give you an example of that. So this is a picture of a guy named Joshua Davey. So Joshua Davey was a student in the state of Washington, and he wanted to study to become a minister. So he wanted to take a degree in devotional theology. He applied to the state of Washington for a merit scholarship that was available to promising students. The problem was that the Washington State program excluded devotional theology degrees from the program, so he was told he was ineligible. He brought a lawsuit. It made it all the way to the Supreme Court. And the Supreme Court, in an opinion by Chief Justice William Rehnquist, no liberal, right, upheld the exclusion of theology degrees from the program. And here's what Rehnquist said. we, meaning the court, can think of few areas in which a state's anti-establishment interests come more into play. In other words, the state of Washington has a good reason for not allowing its scholarship program to be put towards devotional theology degrees. The state of Washington doesn't want to violate the Establishment Clause. Now, interestingly, the court says if the state of Washington had included devotional theology in its scholarship program, that actually would not have violated the Establishment Clause. But nonetheless, the state has an anti-establishment interest. That is to say, the state can act in a way that is consistent with the spirit of the Establishment Clause, okay, without thereby violating the Free Exercise Clause. And ultimately, Rehnquist says there's room for what he calls play in the joints. That's that zone of legislative discretion between the two religion clauses, where the government gets to decide for itself how much it wants to accommodate in the way of religious practice. So I'm sketching out here 4 understandings of accommodation. There's our color-coded chart from earlier, right? So we can imagine a maximalist reading of both clauses, establishment and free exercise, right? Where the orange zone and the green zone are pretty big, and the middle zone of legislative discretion is small or non-existent, okay? This was basically Justice William Brennan's understanding of the Constitution. Or we can imagine, by contrast, a minimalist vision, where there are relatively few accommodations that are prohibited by establishment and relatively few that are required by free exercise. And so in between, there's this large zone where the government gets to decide for itself how much it wants to accommodate religion. This was basically the vision of Justice Scalia, at least for most of his judicial career. Or we could have a separationist vision, where the Establishment Clause does a lot of work, the Free Exercise Clause not so much. This, I think, is the vision of Justice Sonia Sotomayor on the current court. It was the vision, I think, of Justice Ruth Bader Ginsburg when she was on the court. Too early to say about Ketanji Brown Jackson. We'll have to see. Or one could have an accommodationist vision, where the Establishment Clause does very little work, but the Free Exercise Clause requires a great deal of the government in terms of accommodation. And this, as we'll see, is the vision of the current conservative controlling bloc on the Supreme Court. So let's talk about a couple of Free Exercise Clause cases before we finish and turn to the Q&A. This one's a biggie from 1990. It's called Employment Division versus Smith. And you're looking there at a man named Alfred Smith. He was a member of something called the Native American Church in the state of Oregon. And his church had as one of its central sacraments the ingestion of peyote. Well, his employer found out. He was actually working at a drug addiction recovery program, so, you know, not, but you know, he might have been a wonderful mentor in many ways. Apparently he was. But he was using peyote, right? So they fired him. Okay. And under Oregon law, you're not entitled to unemployment benefits if you're fired for workplace misconduct. And one of the ways that you can be fired for workplace misconduct is you violate the criminal laws of your state. Okay, so he applies for unemployment compensation and is denied on that basis. Okay, so he brings a case in the US Supreme Court. He says, wait a minute, the state of Oregon is effectively putting me to a choice, right, between obeying the tenets of my religion on the one hand, right, or getting unemployment compensation that allows me to subsist, okay? That's got to be unconstitutional. You can't put people to that kind of a choice, or so he argued, okay? The Supreme Court disagreed. And in an opinion written by Justice Antonin Scalia, the Supreme Court said no. The Free Exercise Clause does not require the government to give an exemption to a person, an exemption from a neutral, generally applicable rule of conduct, simply because that law happens to incidentally burden a person's religious practice. Okay, so this is, as you can see, a very narrow reading of what the Free Exercise Clause requires in the way of accommodating religion. Now, on the way to doing this, Justice Scalia distinguished some very broad opinions by Justice Brennan that had been written 30 years earlier. He doesn't distinguish them in a very persuasive way in a lot of people's view, but he tries, okay? And ultimately, Scalia says, you've got to leave this question of accommodating religion up to the political process. You put it in that middle zone of legislative discretion. And he says, it's true that leaving accommodation to the political process might place at a relative disadvantage those religious practices that are not widely engaged in, like sacramental use of peyote. But that must be preferred to a system in which each conscience is a law unto itself. So what Scalia is saying is, if you want to ingest peyote for sacramental purposes, go to the state capitol, lobby your legislature, and try to get a statutory exemption. Which, by the way, the Native American Church did, and they got from Oregon after this case was decided. But you can imagine that the groups that want such exemptions won't always be successful in the political process. So this is interesting, right? Justice Scalia, one of the most conservative justices ever to serve on the Supreme Court, a cultural conservative, mind you, a very religious man, interprets the Free Exercise Clause narrowly. There's a story about this. So Justice Scalia used to interview potential law clerks, every year to decide which ones to hire. And he was in the habit for a while of asking these clerkship candidates, tell me which one of my decisions you think is the worst. Because Scalia was very bellicose. He liked to argue with people, get into it. He wanted to make sure that his law clerks were capable of going blow for blow with him. But he stopped asking this question after a few years because everybody said employment division versus Smith is your worst decision. And he was like, that's so uncreative. I knew you were going to say that, right? So conservatives and liberals, actually, thought that the Smith decision was wrong. I will tell you personally, I'm not sure it's wrong. I think it's probably right. But I'm in a minority about that. The US Congress also thought that the Smith decision was wrong. And in response to this decision, Congress passed something called RFRA, the Religious Freedom Restoration Act, which was designed to subject to a kind of strict judicial scrutiny government actions that have the effect of substantially burdening religious practice. And as you guys probably know, many states have also passed many state-level RFRAs as well. So the Smith decision raises a question, and the question is, what counts as a neutral, generally applicable law? Because if a law is that, if it's neutral and generally applicable, then there's no constitutionally mandated free exercise exemption for religious practitioners. Let me show you a case that came up a few years after Smith, called Church of the Lukumi Babalu Ai versus City of Hialeah. So the city council in Hialeah, Florida, became quite concerned about local parishioners of the Santeria religion, which is a religion from the folk religion from Cuba, okay, who were practicing ritual sacrifice of animals. And so the council passed an ordinance making it a crime to sacrifice an animal for ritual purposes, okay? Now, the ordinance contained a pretty interesting exemption for slaughtering by licensed establishments of animals specifically raised for food purposes. This is an exemption for kosher butchers, okay? This is like the shochet exemption, essentially, in the statute, right? So this case makes it to the Supreme Court, and the Supreme Court, in an opinion by Justice Anthony Kennedy, strikes down this ordinance Why? It says this ordinance is not governed by the rule from Employment Division versus Smith because it is not neutral and generally applicable. The legislative history and the text of the statute indicated to the court that this was an ordinance that was targeted specifically at the practices of the Santeria religion. There was lots of evidence in the record that that's exactly what had happened here. So what you get from the combination of Smith and this Hialeah case is neutral, generally applicable laws are perfectly constitutional. They don't need to exempt religious practitioners. But if there's evidence of hostility towards religion, evidence of targeting of religion, that's a different story. Briefly, fast forward to 2021, the COVID pandemic. The state of California, like many states, enacts social distancing requirements. The social distancing requirement in California, among other things, said that gatherings, social gatherings, were limited to at most 3 households, okay? They want to restrict the spread of this disease. That restriction is challenged in the US Supreme Court. It doesn't even go to full briefing and argument. This is one of the cases on the so-called shadow docket where it was decided on an emergency stay application. I don't want to get too technical. But the court ultimately strikes it down. Why? The court says, well, the California regulations allowed other kinds of businesses to stay open, like certain kinds of retail establishments, for example. And what the court says in its decision on the California COVID regulation is that a law is not considered neutral and generally applicable if it treats any comparable secular activity more favorably than religious practice. So you can see the court is no longer requiring the kind of evidence that we see in the Hialeah case of hostility toward religion. Now the burden is on the other side, and the court says as long as religion is being treated less favorably than any secular comparator, that religious practitioner has a winning claim under the Free Exercise Clause. Okay, last couple of cases. Remember Locke versus Davey? That was the theology student in the state of Washington who couldn't get his scholarship because he wanted to put it towards a degree in devotional theology. Well, a similar issue came up in a case called Trinity Lutheran Church. So Missouri had a program that provided grants for institutions that wanted to resurface their playgrounds using like recycled tires and rubber. You've all seen those, you know, it's good for the little kids' knees and stuff. They don't get scuffed up, right? So a church, Trinity Lutheran Church, has a playground. You can see it there. They applied to this program and were told, nope, sorry. The Missouri Constitution has a provision in it, the state constitution, mind you, that says no state aid can go to a religious institution. So you, Trinity Lutheran, you're not eligible for this playground resurfacing grant. The Supreme Court, in an opinion by Chief Justice John Roberts, said that violates the Free Exercise Clause. When a state denies an otherwise generally available benefit simply because of the religious status of the recipient, that's unconstitutional. Well, wait a minute, that sounds a lot like what happened to Joshua Davey, our theology student. Well, the Chief Justice said, no, Locke versus Davey, that other case, that's different because the state of Washington in that case denied him a scholarship based on what he wanted to do with the money. Whereas Missouri is denying the grant of the Trinity Lutheran Church simply because Trinity Lutheran Church is a church. Now, if that distinction between conduct and status makes sense to you, you're smarter than I am. Okay? And interestingly, in this case, you get a separate opinion from Justice Sotomayor on the court's left wing saying, that makes no sense. and a separate opinion by Justice Neil Gorsuch on the court's right wing saying that makes no sense. Both of them recognize, right, that everything a church or religious institution does is wrapped up with who or what that institution is. There's no distinction to be made there, right? The court is effectively overruling the Locke versus Davey decision. One more case I want to show you before we close. This is from just this year, just this past spring. Carson versus Macon. What's going on in this case? Well, Maine is a very rural state. And there are plenty of counties in Maine that don't even have a public high school. Okay, because people live so far away from one another, right? And so Maine has had this program for a while that says if you live in one of these rural counties, you get to choose what secondary school your child will go to, and the state will help pay the tuition, if there is tuition, if it's a private school, because you're allowed to use this state money for both private schools or for things like buying textbooks and transportation and so forth with respect to public schools. But Maine says sectarian schools, that is religious schools, are exempt. You're not allowed to use this money to send your kid to a religious school. Well, you can see the plaintiffs here in front of their school of choice, the Bangor Christian School. They challenge it. It goes all the way to the Supreme Court. And the court, in another opinion by Chief Justice Roberts, relying on that Trinity Lutheran playground resurfacing case that I just mentioned, strikes down Maine's program. The court says you can't exclude religious schools from your funding scheme. Now, of course, the reason that Maine wanted to exclude religious schools was it didn't want to violate the Establishment Clause. Think back to Everson and Justice Black. If there's one thing, Maine says, that the Establishment Clause means, it means that government money can't flow to a religious institution. Not so, says the Supreme Court. A state's anti-establishment interest does not justify enactments that exclude some members of the community from an otherwise generally available public benefit because of their religious exercise. Justice Sotomayor, in dissent in these cases, makes a point that I think is valid, which is that the court used to believe in the separation of church and state. Now it's as if the majority on the Supreme Court believes that separating church and state violates the Constitution, far from being required by it. So if we go back and think about our four understandings of accommodation that we talked about earlier, maximalist, minimalist, separationist, accommodationist, we can see that with the current conservative majority on the Supreme Court, it's the accommodationist vision that rules the roost. A narrow understanding of the Establishment Clause and a broad understanding of what the Free Exercise Clause demands on the part of our federal, state, and local governments. Okay, I'll end it there, and I'm happy to take any questions that you guys have about all of this. Yeah, go ahead. Oh, I guess there's a microphone coming around.
Hi. Hi. Well, thank you for your talk. It was very interesting. But I'm curious, all of your examples had to do with a Christian
Not all.
organization. Or, let me rephrase, Judeo-Christian organization. Like, have there been examples of Buddhist, Hindu, Muslim, or other groups that are in this recent, with this current court, where they are taking this accommodative view?
Which I see with the current court. Right, I mean, so Alfred Smith of the Native American Church would be a counterexample. He lost, right? Ultimately, he got his accommodation from the state legislature, but he lost in the Supreme Court. So, not so much. The current court has not been as solicitous of the interests of non-mainstream or even non-Judeo-Christian religions. I'll give you an example. There were a couple of cases that came up. Again, the court's shadow docket, that's where it doesn't take full briefing and argument. It decides cases on an abbreviated schedule. But a couple of death penalty cases recently where you had, in one of them, a Muslim prisoner on death row who wanted his imam, his spiritual guide, to be in the death chamber with him when he died. The state said, we don't allow that, right? And he went to the Supreme Court and he said, well, the state needs to accommodate my sincere religious belief. The Supreme Court said no. Interesting, right? Later case arose in which you had a Christian death penalty defendant with a similar claim, and the court was more receptive. So it is interesting to sort of think about whether the court is playing it straight with respect to people of different religions who bring these claims. I think the jury's still out on that. There haven't been enough cases to really make a definitive judgment about that. But it's something that definitely bears watching. The court has been solicitous of the interests of Jewish organizations. So there was another COVID case out of New York in which a Jewish congregation, synagogue, challenged social distancing regulations, and they prevailed in the Supreme Court. So yeah, it's a mixed record, and it's a little bit too early to say because the sample size is small, but it's a great question. Yeah.
I understand that there are some cases now. There's a case in Florida challenging the anti-abortion law in Florida on the basis of free exercise of religion. It includes some Jewish congregations. Do you have some thought as to where that's headed and where that might fit in the current schema?
So the question is about a challenge that's been brought by a synagogue in Florida to Florida's new restrictive abortion law. So Florida has a law that bans abortions at 15 weeks of pregnancy. So that's pretty restrictive, but as you all know, the Supreme Court overruled Roe versus Wade, and so states now apparently have the power to enact those kinds of regulations of abortion as a general matter, right? But then the question becomes, right, how does that interact with what we've just been talking about in terms of mandated exemptions under, say, the Free Exercise Clause? Now, the case you're referencing, there's a congregation in Boynton Beach, Florida called Congregation Lador Vador, progressive Jewish synagogue, that brought a case challenging that Florida law and saying that under Jewish law or their understanding of halakha, women, certainly women who have a risk to their health, but I think their claim really goes beyond that. They say women ought to have the right to decide for themselves about whether and when to terminate a pregnancy as a matter of Jewish law. Okay, so this tees up these questions quite nicely. Now, their claim technically arises under Florida's state RFRA law. So Florida has a law that says that if the government substantially burdens religious exercise, right, then a plaintiff who raises a RFRA claim is entitled to an exemption from that law unless the government can prove that it has a compelling reason for the law and that it's necessary as opposed to simply their idea of good policy. So that case is very much still ongoing. I don't know how it's going to come out. It's been interesting to me that some conservative commentators who you would ordinarily think of as pretty receptive to claims of religious exemption have tried to argue that this claim should fail So there's a conservative commentator who I won't name, but who's very active on Twitter and elsewhere, who says, this claim should fail because when it comes to Judaism, there actually is no such thing as binding Jewish law. Now, or he says, outside of the Orthodox movement. So he says, conservatives, Reform Jews, they're all just deciding for themselves, right, what they think is right. And that can't be the basis for a claim of religious exemption under the Free Exercise Clause or under a RFRA law. This strikes me as very badly wrong in a couple of different ways, right? I'm not a halachic scholar, but I don't think it's at all accurate to say that the Orthodox have a sort of monopoly on binding understandings of Jewish law. But beyond that, as a legal matter, right, to prevail under the Free Exercise Clause or on a RFRA claim, right, you don't have to show that your religion binds you to a particular course of conduct. Instead, what you have to show is that you have a sincere religious belief and that belief is being substantially burdened. In fact, the text of the federal RFRA makes it clear that you don't have to show anything more than that. So if doing something that the law compels you not to do, right, is nonetheless consistent with your religious beliefs and values, then you ought to prima facie have a claim. Okay, so I don't know how that case is going to come out, but I think it would be highly ironic and problematic if the courts that have been so receptive to these sorts of claims of exemption suddenly turn around and say, when it comes to abortion, right, the exemption claim fails. But we'll have to see. Over here, one or the other.
Thank you for your very enlightening conversation. Can you hear? Anyway, comment on the Pledge of Allegiance. It didn't always have that little thing called "Under God."
Right.
Okay, and so your thoughts, please.
Sure. So the question was about the Pledge of Allegiance. So the words "under God" were added to the Pledge of Allegiance in the early 1950s, in the Eisenhower era. It wasn't ever thus. And in fact, the Pledge of Allegiance has been challenged in a case that made it all the way to the Supreme Court. So there's a man named Michael Newdow who lived in California, who was interesting guy, atheist, medical doctor, and a lawyer, brought a claim on behalf of his school-aged daughter saying, my daughter shouldn't be compelled to say a pledge that has the words "under God" in it. That violates the Establishment Clause. He also argued it violates her free speech rights because the government can't compel individuals to become mouthpieces for government positions or government orthodoxy. So in that particular case, this was also in the early 1990s, right around the time of Lee versus Weissman, okay? The Supreme Court clearly was sort of nervous about this case. It was 1992, it was an election year. You guys may remember that election. That was the election that gave us the presidency of George H.W. Bush. And the Pledge of Allegiance was like a central, hot-button political flashpoint issue, right? Those were the days, right? And the Supreme Court was quite nervous about this. And it dodged the question by holding that Mr. Newdow didn't have what's called standing to bring his case. Essentially what it said was, ordinarily parents do have standing to bring cases on behalf of their children, but only if they're the custodial parent. And we think that because Mr. Newdow is divorced and the mother doesn't support the lawsuit, and California's courts seem to indicate that she's the custodial parent, he doesn't have standing, which was quite strange. But you can understand why the court was motivated to dodge the issue. However, several of the justices wrote separate opinions in that case, saying they didn't buy the standing argument. They wanted to reach the merits of the case. And you had, for example, Justice O'Connor, Sandra Day O'Connor, who was sort of the center of the court at that time. And what she said was, yeah, I understand the words under God are religious words. But she said, they're sort of like the words in God we trust on our currency. Or they're sort of like the way that the marshal of the US Supreme Court says, God save this honorable court before every session of the court. It's a kind, said O'Connor, it's a kind of ceremonial deism, D-E-I-S-M. That's the term she used. Now, the deists were people like Thomas Jefferson, who believed that sort of God was like a watchmaker who set the mechanics of the universe into motion and then receded, right? So I don't quite know why she used those words, but what she meant by it was there are certain religious expressions, okay, that may have begun their lives as irreducibly religious things, but which over time, out of familiarity and repetition, have become sort of laundered in a way that they just become part of the fabric of our society, right? I mean, when the rabbi in Providence, Rhode Island gave that invocation at the Providence Middle School graduation with language like God of the free, hope of the brave, right? He was trying to tap into the same idea of ceremonial deism. Now, ultimately, right, in Lee versus Weissman, the court said it was still unconstitutional. So it remains to be seen. However, the current Supreme Court, I can guarantee you, right, they're not at all troubled by things like the Pledge of Allegiance. And I'll tell you why. I didn't talk about this case, but a couple of years ago, the Supreme Court had a case about a giant cross in Bladensburg, Maryland, outside of Washington, D.C., that is on government property and it's maintained by a local government commission, okay? Giant cross, okay? You can't miss it if you're driving by, 20, 30 feet high. And this was challenged as a violation of the Establishment Clause. The plaintiff said the government is effectively endorsing religion by maintaining a Christian cross on public property. And the Supreme Court said, no, the cross stands for the sacrifices that were made by soldiers during the First World War. And the retort to that is, well, what if some of those soldiers were Jewish, right, or Muslim, right? And the court said, well, A, there's no evidence in the record that any of them were Jewish or Muslim, right? But more importantly than that, right, everyone understands, right, that you see things like crosses in graveyards, and you just think about the sacrifice of the fallen soldier. You don't think about religion. Now, I don't think I agree with that. But further, right, several members of the court said, even if the cross is a religious symbol, in their view, it doesn't violate the Establishment Clause for the government to recognize, endorse, or even sponsor that display, because the Establishment Clause isn't violated by mere government sponsorship of a religious display. So you can see how narrowly the conservative justices on the Supreme Court are reading the Establishment Clause. So I think the Pledge of Allegiance with the words under God is safe for now.
Okay, so we're going to take one more question, and then we're going to wrap up.
Okay, so as you were talking about these visions, understandings of accommodation, it occurred to me that they've shifted back and forth over the course of recent history with the composition of the court. So I guess I'm curious what your response is to, especially thinking about the dominance of the 6-3 conservative supermajority today. What's your response to those who are proposing that we change the composition of the court and we add justices so that effectively the executive branch has more of an opportunity to influence the number and direction of the voices on the court than is currently possible today with, what used to be called the 9 old men?
So can everyone hear the question? So yeah, this is an incredibly important and difficult question. We could talk for hours about it, and it's the last one for tonight, so I'm going to try to be brief. So I'll say a couple of things. As you might gather from my talk, I'm very concerned about some of the directions that the Supreme Court is pushing our law in, not just in the area of religion, but the area of race, of law of democracy, and the law of reproductive rights, and many other areas as well. It's concerning to me how nakedly partisan some of the outcomes and, frankly, some of the reasoning in the court's opinions has become. It troubles me how much authority, how much power the Supreme Court has, right, in a system where, notwithstanding even in view of the results of the election earlier this week, right, we have an incredibly closely divided Congress that is often unable to act. We've got an executive branch that, for various reasons, is sometimes unable to act. And so the court comes in and fills that vacuum in ways that I think are problematic, not just from the standpoint of substantive outcomes, but also from the standpoint of the proper understanding of how our government should work. So I'm troubled by that. It is true that there's nothing in the Constitution that mandates that there be 9 Supreme Court justices. That number is not fixed. It has changed over our history. So in the era of the Civil War, the number of justices briefly went up to 10. It then went back down to 8, and then back up to 9 again. Back in the early days, the time of Chief Justice John Marshall, there were 6. So it wouldn't be, I think, unconstitutional for Congress to expand the size of the Supreme Court. Now, politically, I think it's a non-starter. I mean, there's a effective filibuster requirement, the 60-vote requirement in the U.S. Senate. So even if the runoff in Georgia leaves the Democrats with 51 instead of 50, that's nowhere near 60. And frankly, you have people like Joe Manchin and others within that Democratic group who are not willing to override or repeal the filibuster requirement. I also think I'm a little bit uneasy with the idea of raising the number of justices, because you could set in motion a kind of tit for tat, right, where it goes up and then the next time the Republicans get into control, they raise it again. There are other things to think about. There are ways to restrain the jurisdiction of the Supreme Court. I would love to see, I think this is also very, very difficult to accomplish in our political climate, but I would love to see a constitutional amendment that gets rid of life tenure for Supreme Court justices. I think it is absolutely inconsistent with democratic values for these justices to be able to serve 30, 40, 45, maybe even more years on the court. They're being appointed younger and younger precisely for that reason. And then you have this sort of macabre specter of a sort of death watch with people at the end of their careers, like Justice Ginsburg, right? Who people were sort of hoping that she was going to do, enough push-ups to make it through the Trump era, right? That can't be the way that we run our judiciary. So I would love to see single, non-renewable 18-year terms for Supreme Court justices. That would give every president, under normal circumstances, the opportunity to appoint 2 justices. They would be with staggered terms. There are ways that you could possibly arrange it so that the current justices still can serve in a kind of retired capacity so that they're not being kicked off of the court, and so on. It would also allow, I think, the appointment of older people, right? So you wouldn't have the political elites going out and looking for 40-year-olds to serve on the Supreme Court. You could get somebody as old as me on the Supreme Court because, probably going to make it another 18 years. But that would require a constitutional amendment, and in our day and age, the Constitution is practically unamendable. So it's a really difficult and important problem. I don't have a magic solution for it. Thanks, everybody.
Thank you so much, Professor Franklin. Thank you to all of us for joining us this evening, and thank you for your questions. We have some refreshments up in the social hall, so please join us upstairs so you can continue to maybe unpack some of what we learned this evening. Thank you all.
Thank you.
Thank you.